My name is Rebecca Lyford, and I am interviewing Joe Johnston, Johnsson,
S-T-O-N.
S-T-O-N. He's got a very interesting story. So I'm just going to go over the very beginning stuff. And he was born in Los Angeles, California in 1944. He lived in Pomona, California. His mother, his father, and his younger sister, and he lived there until 57 when they moved to Bristol, Tennessee. His father moved the family to Bristol for employment reasons. He graduated from Bristol, Tennessee High School in 62. He attended UT Knoxville from 62 to 64. When he decided to major in political science, he transferred to GW, George Washington University in 1964, and matriculated in 1966. Now, what did you do in the summer of 1964?
1964 was the transition period for me. I had just decided to major in political science. And the Democratic convention for the presidential election was in 1964, that fall. So I decided that it would be prudent for me to sit at the feet of the powers. And so I made arrangements to travel to Philadelphia, where I stayed at a fraternity house and got a part-time job as a janitor in a B.F. Goodrich Tower house for about 2 months. After that, I moved on to Atlantic City, New Jersey, where the Democratic Convention was being held. Through family connections, I was able to finagle a delegate pass that enabled me to go to the convention floor. And I was not terribly impressed. All of the delegates from Tennessee anyway were drunk most of the time. And so the convention lasted about 4 days. Nobody was paying attention to anything any of the speakers said, but they were having a good time. It was more like a Roman orgy than it was a convention. Anyway, that was my first introduction to the realities of federal politics. So that fall, I started at George Washington University in Washington, D.C. And to keep myself from absolutely going crazy, I had to get engaged in some athletic events. And so I took up crew, and it's not something for the faint-hearted to do. In 1965, I was on the junior varsity crew and on varsity crew in 1966, my last year. I was elected co-captain of the crew at that last year. We lost a lot of races that year by less than a half a length, which is really tough. One race against Amherst, we lost by half a stroke, which is a bad way to lose a race. But I did learn from that Amherst race that you don't slow down rowing until you hear the final whistle blow. And so that was learned. That's a lesson that I have learned and tried to keep in mind during most of my personal and political career and legal career. So anyway, after George Washington University, I had a choice of either being drafted to the United States Army or joining the Air Force, going to law school, going to graduate school, or going to the Peace Corps. Either of these things were possible. I did not relish going into the military. Vietnam was heating up, and I did not relish the idea of having to go out and do harm to people. So my other choices were the Peace Corps, graduate school, and law school. I was not ready for law school. I was tired of school. Graduate school, I was tired of school. Did not want to go to school. Peace Corps. So I signed up for the Peace Corps. I really wanted to go to Africa, to get as far away from Vietnam as I possibly could. While in the Peace Corps, I'd have another draft deferment for at least 2 years, and I figured, well, the war in Vietnam will be over by that time, so I won't have to worry.
A little Little did you know.
Little did I know, little did anybody know, but in any event, part of the application for becoming a Peace Corps volunteer was an aptitude test, a language aptitude test. And I have to confess that I was very poor in foreign languages. It took me 3 years to get through 2 years of French in college. And that was a struggle to me. But in the language aptitude test, it was a very simple test, actually. It was a list of 100 nonsense syllables paired up with English words. And you had 2 minutes to memorize this list and then to rearrange and coordinate the nonsense syllables with the words on the next page after 2 minutes. Well, I said to myself, "Self, you're doomed." But I had some test sense. And so I said, well, I might survive if I memorize the first column and don't worry about columns 2 and 3. So I memorized the first column. It turns out that most of the questions and pairs on the second page were from column 1. So instead of barely passing the language aptitude test, I scored exceptionally high, which qualified me to go to Thailand, which has one of the most complex tonal languages in the world. I think Vietnamese has 6 tones. Thai language has 5. But nevertheless, I was signed up for it. I had to struggle through it, and I managed to do that. Peace Corps training involved 6 weeks in Hawaii, which was great, except that we were studying all the time. You didn't have time to really enjoy the island or the surroundings or the beach. After 6 weeks, we were transferred to Manila in the Philippines, and we were housed in a slum area of Manila. This is to acclimate ourselves to what rural or urban lower class, economic class people might have to endure. Paco Market, I think, was the area of Manila that we were housed in. While there, we had to study at the World Health Organization Malaria Eradication Training Center, because the program I was going into was one involving the eradication of malaria, a highly transmissible disease that was plaguing not only Thailand, but every country in Southeast Asia. During the time we studied at the World Health Organization, we studied hematology, study of blood, parasitology, which that's because malaria is transmitted by a parasite called Plasmodium, and then finally entomology, which is the transmission of diseases. So we really were focused on what would be necessary to function as a field supervisor in a malaria eradication program that was planned to be countrywide for the country of Thailand. And my official rank as a Peace Corps volunteer within the Thai government was assistant zone chief. And we were responsible for the malaria program for 3 southern provinces on the Thai Malay Peninsula. That was Ranong, Chapon, and Sarathani. In any event, I was there for 3 years, and fortunately, by the time I was there for more than 6 months, I learned to speak enough Thai to be able to order a meal by myself and ask where the restroom was, and things like that were essential. By the time I finished my 3 years, I had a foreign service index rating for my language aptitude is 3 out of 5, which meant that I had conversational type plus specialty language in whatever work I was doing. So I made it through. But after 3 years, I was going to lose my deferment, and believe it or not, the Vietnam War was still going on. This is 1969 now. And so I was very depressed with the prospect of being drafted and serving in a situation that would require me to shoot and kill or bomb and destroy villages and villagers in the name of saving the world from communism. And I had no feeling for that at all. It was very, very depressing. One of my Thai doctor friends that I met in Chumpon recommended that I go to a meditation center that he had attended when he got out of his military service, and that it helped him with anxiety and depression. And so I took his advice and went to Chonburi, which is a little town 60 kilometers east of Bangkok. And there was a meditation center there. They called it Wat, which means temple in my language. Wakiso, what we Wakiso, and it had an abbot there who was Burmese. He spoke with a very heavy Burmese accent, and I could barely understand. With the assistance of a German Buddhist monk that was also taking the meditation course that summer, we were able to communicate the instruction that was necessary for me to participate. The abbot was a political refugee from Burma. Several years before, the Burmese had a military coup. And as a result of the coup, anybody that was overseas at the time was considered to be an enemy of the state. And she had been assigned to go to Thailand to teach insight meditation or vipassana meditation through the Thai monastic order here in Thailand. So he was basically unable to go back to Burma or face possible arrest and worse. So the Thai monastic orders arranged for him to teach vipassana meditation at this meditation center in Chumpon, in Thailand, Thailand. Now, this is really interesting. He was internationally known, and the Buddhist meditation center, well, what we was internationally well known, but locally, the people there did not know anything about it. So when I first arrived and asked about how to get to this place, I was given misdirections by several well-meaning people who did not really understand what the meditation center was. It was only when I went into a Chinese-owned bookstore that I entered into a conversation with the owners, and they asked me questions like I was used to getting, like, how come you speak Thai language? How long have you been here? Why did you come to Chonburi? And I told them that I wanted to go to Wat Wekasong, that I had a letter from a Thai doctor recommending that I go. And they asked me where I was going, and I told them where I had been told to go. They said, no, you do not want to go there, here. They took me outside and ordered a sound law, which is a 3-wheel tricycle that it has a driver and you sit in it with a bucket in the back. And they told him how to take me to Wat Wekasong. And it was very interesting. But I did finally arrived. And I got in there and looked around, and I couldn't find anybody. Everybody was gone. So I started wandering around, and I saw a Buddhist monk. He apparently was washing some of his robes, his garments. And so I spoke to him, and he did not speak back. That's unusual. I spoke to him again in Thai. He ignored me. So at this point, I saw across an open field 3 elderly monks walking very rapidly toward me. And they asked me, one of them was the abbot who Asabat Tera. He asked me what I wanted, what I was doing. Apparently, they had started this very organized meditation retreat for all of the monks that had signed up for the course. And one of the rules was there would be no talking, no speech, except for 15 minutes at a specific time during the day when they would receive counseling from the meditation master or the meditation teacher for that particular monk. Otherwise, it was a vow of silence. And that's why the first monk that I met would not speak to me, ignored me entirely. Well, the abbot asked me what I wanted, and I tried to tell him that I had been recommended to study something about meditation because I was depressed and concerned about my future as a soldier and having to kill people. I said, well, we don't take the students here. You're about 10 days late. Started the program already. You can't be. Well, in the meantime, 3 other people joined our group. They were Chinese businessmen. They were actually the financial supporters for the temple, the meditation center. And they decided that having a Westerner, a Farao, as a student would enhance the reputation of their meditation center. And they very much encouraged the abbot to reconsider. And the abbot, being a very practical Buddhist monk, understood that since they were paying bills, they should have some say-so. And so he agreed to take me on as his own meditation student. But he said, you will have to stay 3 months. I did not know the religious rank of Wat Tara at the time. I was speaking to him in complete ignorance of Buddhism and Buddhist tradition. And so I was very casual with him, but in fact, he was probably the equivalent in Christian religion or Catholic religion as an archbishop. And I was talking to him very casually, without the appropriate amount of respect that I should have accorded him. In any event, I said, finally, well, I will agree to stay 6 weeks. And if at the end of 6 weeks, I feel like I am making progress, I'll stay the full 3 months.
Joe, I hate to say this, but can you just wipe up? We're going to go back to your malaria education.
Okay.
And then we're going to wind up so tell us, you told me that being a Peace Corps volunteer made you an ecologist through personal experience and observation. Could you just kind of tell me that story about the DDT?
Okay, we can do that too. But the long and short of it is, with respect to the Buddhist Meditation Center, I did stay the 3 months. If you want to go on to the malaria eradication, we can do that. The theory behind malaria eradication at the time was that the Anopheles mosquito was the vector that transmitted the blood-borne Plasmodium parasite from human to human. And the idea was, the theory was that if you interrupted the transmission, while at the same time treating people that had malaria, so that there was no reservoir, if you will, of parasites or the mosquito population become infected, eventually, within a few years, the parasite population would be so low, there'd be no transmission at all. So, or at least a transmission level that was easier to control than what they had. So, yeah, what do you do for that? Well, they had water-soluble DDT, 5% water-soluble DDT that was touted as being perfectly harmless to people, animals, birds, and only cause problems for insects. The idea was you spray every hut, every household in the country with water-soluble DDT once every 6 months. The idea is that the mosquitoes that are known to bite at nighttime will enter the houses at night. Most people would be in their houses at night. So the mosquito, in trying to find a human target, would go and land on the wall, be exposed to DDT and die. Or if the mosquito, was a little resistant to DDT, by the time he found the second victim, he would probably die. In any event, the mosquitoes would be dead on the floor, along with every other insect in the house or the hut. Now, this is in the tropics, and insects are an accommodation that everybody has to tolerate. So, in this case, all of the insects that were exposed to DDT would fall on the floor. The floor had to be cleaned because folks ate on the floor, slept on the floor, did everything on these hardwood floors. So the floors were swept clean, and these dead insects that had been infected with DDT were then tossed out onto the ground. Well, on the ground below these houses, which were on stilts, you had chickens, and you had ducks, and you had pigs. This is what most of the villagers had to support their families. They got eggs from the chickens and the ducks. Well, what happened? Well, the insects that had fallen to the ground were insects that these birds would eat. So, sure enough, the duck and the chickens ate these DDT-infected insects. And guess what? They died. Okay. And then the pig or pigs, if there was more than one, would see the dead birds, and they would eat the dead birds, get infected with DDT, and the pigs would die. So now the farmer and villager no longer has chickens, ducks, eggs, or pigs. Have you helped the farmer villager now? There's more. Well, after having wiped out his meat supply and his egg supply, the next victim was the villager's cat. All the villagers that I came in contact with, if they were storing rice, would keep a pet cat to keep the rodents away from the rice bins, to keep the rice from being despoiled or eaten by the rats. Well, the cats would brush up against the walls and get DDT on their fur. They would lick the fur to clean themselves. And guess what? The cats died. So all of a sudden, there's no cat to protect the rice from the rats. And the rats, it just so happens, were highly resistant to DDT. They didn't care. So the rice bin and rice for the year was spoiled by the rats. So what have we done for the villager now? The DDT eradication program has wiped out his meat supply, his egg supply, and his rice. Is there more? Yes, there's more. We have in South Highland, where I was working, most of the villagers had roofs on their homes made of palm thatch. And in this palm thatch, there resided two types of insects. One was a moth larva, and one was a wasp larva. Now, the wasp larva would eat the moth larva. And there was a balance there so that the palm thatch roof would last about 6 months before it had to be replaced. Now, what happened? With the spraying of the DDT on the roof, both insects were exposed to DDT. One of them was highly susceptible to DDT, the other one was not. Which one? Most susceptible to DDT was the wasp larva. So the wasp larva died and the moth larva did not. The moth larva then devoured the roof. So the roofs that would normally last 6 months, would last about a month. It had to be replaced. What does this do? This puts a nice fresh roof free of DDT for the mosquitoes to land on. And so you've lost your protection from the DDT as well as destroying the roof for the family.
Now, when the spray team, they come every 6 months, what would happen when the spray teams would get, you told me a very, what would the villagers tell the spray team?
Well, the second time in the cycle, they questioned the spray team thing, you know. Well, one other thing happened. Yeah, and this is also important. Most of the villagers had something called a good luck dove. And this was a small dove that was captured and placed in a small bamboo cage. And this cage would be hoisted on a 15-foot high pole every morning before dawn. And so the dove would see the sunrise before the human population would. If the dove sang in the morning, it was going to be a good day. If the dove did not sing, it was not going to be a good day. For example, if there was a monsoon season and there were heavy clouds coming in, the dove would not sing. Well, doves are apparently highly susceptible to DDT. And even inhaling the DDT fumes from spray that was being done 50 feet away would cause them to die. So the good luck doves, all these villagers were dying. That indicates very, very bad luck, a very, very bad day. So when the spray teams come back the next year, the villagers complain, says, you know, after you left, we had all these problems. Our chickens died, our ducks died, we have no eggs, our pigs have died, our rice is ruined, our roofs are falling down, and our doves have died. And the team leader would say, well, it's just your bad luck. It's evidenced by the fact that your dove died. If your dove hadn't died, you wouldn't have bad luck. So the villager said, well, okay. So they spray again. And believe it or not, same thing happens. Ducks die, chickens die, pigs die, rice crop ruined, roof fails. So by now the villagers are really upset. So on the third cycle, the spray teams come by, and the villagers said to the team, if you spray our houses and our huts, we're going to have to kill you. And the spray team leaders say, look, that's kind of serious. We're just doing our job. The government has ordered us to do this. We've been told to tell you that there's no harm from the DDT. Whatever's causing this problem is not the DDT. And the villagers say, we don't care if you spray our houses, we're going to kill you. So Thai folks are very ingenious about working out social problems. So they talked about it. So what can we do? And they finally agreed to this formula. The spray teams would not spray the houses. If inspectors came by to see if the houses had been sprayed, the villagers would lie and say, yes, our houses have been sprayed. And the report would reflect that the houses had been sprayed. What happens? The malaria workers praised for their good work because they have 100% compliance with spraying. The reports are excellent. The supervisors that inspect afterwards are told flat on by the villagers that these houses have been sprayed. And the spray team gets promoted. The team leader gets promoted to supervisor, so he can certify the accuracy of all of his reports. The villager, of course, is excited because now he has ducks, chickens, eggs, pigs, and rice, and a roof. So everybody seems to survive. But what about the mosquito? Well, part of the malaria program, besides the DDT spraying, was the distribution of anti-malarial drugs to treat the malaria infection. There was a cocktail that was given. It was made up of chloroquine, primaquine, and pyrimethamine, 3 highly active ingredients, none of which by themselves would be enough to knock out the malaria, but it would be enough to treat the symptoms. Well, the government program had workers that would come out to the villages and take blood samples from any villager that had a fever within the previous week. And that blood sample would be taken back to a lab and examined. If there were parasites found, they would come back and give anti-malaria medication. So although the villages were suffering from malaria, they were also being treated with medication. The medication was insufficient to eradicate malaria, but it was sufficient to control malaria. And the population was satisfied to the extent that the government was doing something to help them after it decided not to kill all of their animals and ruin their rice crop. So the program on paper was an outstanding success that WHO could brag about.
Who could brag about?
WHO,
Oh,
World Health Organization,
okay.
could brag about on paper because it was 100% coverage and the incidence of malaria was way down. This all kind of blew up during the last 3 months of my 3-year term when we had a wave of malaria from the Burma border come over. Mosquitoes don't respect the border, and so we lost most of the progress we've made in terms of infection rates and endemicity rates. But people were happy because they had food and shelter and they had medicine.
Okay. Now, you had lost your exemption, being in the Peace Corps, and then did your parents hire George Barrett to file a CO for you, conscientious objector?
That's true. While I was in the Buddhist meditation center, I applied for a conscientious objector deferment or exemption based upon religious beliefs. And so I managed to get a letter written in Thai with a translation in English from the abbot confirming that I was his meditation student at this meditation center. And George, at that time, a very prominent attorney here in Nashville, he was the personal attorney for Albert Gore Sr., who was the state senator in Washington at that time, an anti-war opponent. And he was also a personal attorney for Richard Fulton, who was the congressman for Middle Tennessee. And so when he wrote a letter to my draft board in Bristol, asking them to consider my application for conscience objector, plus the fact that I was obviously tied up in some foreign religion that nobody knew anything about, they decided that I was probably not going to be a good soldier. Anyway, so they gave me the first conscientious objector status rating that had been given out since World War II.
At Bristol?
In Bristol.
Yeah. Okay. Okay. And then what was your alternative service for the CO?
Well, I had to have, Peace Corps service did not count as alternative service. So I had to do 2 years of work that was approved by the draft board to fulfill this obligation. And I managed to get a job at the Vanderbilt Medical School anatomy department as a lab technician for 2 years. And I was doing work there.
Then when you came back to Nashville for the anatomy job, tell me about your grandfather's house and where you were living and what happened.
Well, I came back to Nashville in 1970 and found that my grandfather's house on Vanderbilt Place, it's 3013 Vanderbilt Place, was in the middle of an urban renewal project that was designed to accommodate Vanderbilt University's proposed campus expansion by 120 acres. And right in the middle of that acreage was my grandfather's house. Under the Federal Housing Act of 1958, urban renewal program could be utilized to acquire property for colleges and universities offering 4-year degrees, which Vanderbilt obviously qualified for.
And this was on Vanderbilt. What was the address of your father's?
3013 Vanderbilt Place.
Okay, sorry.
So anyway, the taking of property for use by a private university appeared to me and to a lot of people to be in violation of the Constitution, which says, I think the Fifth Amendment says that government will not seize property without a public purpose and with just compensation. And so what constitutes a public purpose? Well, this was the subject of litigation, whether Vanderbilt's campus expansion would constitute a public purpose.
So you became a community organizer at that point as a result of this?
Well, my neighbors were mostly in their 70s and 80s, and they were impressed by my youth and enthusiasm and outrage. They had been pretty well burned out by what was going on and what was happening to their homes. So I helped organize the University Center Project Area Committee, which became the officially recognized citizens advisory body to the Housing Authority that was in charge of administering this project. The formula was that every dollar that the university spent acquiring property within its condemnation area would be counted as a local share, matching share, for $2 of federal money. For every dollar Vanderbilt spent, the city would get $2 for capital improvements. So it was a windfall for the city of Nashville and for Vanderbilt at the cost of a sacrifice of the constitutional rights of these elderly homeowners. My grandfather would have been one of them, except he had passed away in 1967, and so I was living in that house.
Now, when your committee proposed amendments to this project, it caused Vanderbilt a lot of headaches. So what happened as a result of that? What did the university ask your supervisor at the anatomy department to do?
Well, they were upset with some of my activities that were causing them some embarrassment. And they asked the chairman of the department, Dr. Jack Davies, if he'd just go ahead and fire me. And if I got fired, then I'd lose my status as a conscious objector because I wasn't doing alternative service. And I would be probably shipped out of town pretty quick. And Dr. Davies said no, that because of academic freedom, what I did on my own time was my business. And as long as I performed the job in the anatomy department as required, that he had no objection and he would not fire me.
Okay, then after 2 years, you finished your alternative service obligation at the anatomy department, and then you were hired as a program developer at VIPS, right? Vanderbilt Institute of Public Policy Studies. And what did you do at VIPS for those 2 years?
I was there at VIPS for about a year. This was in 1973. Yeah, I did alternative service from 1970 to 72. 73, I was with BIP. The director was program was Professor Jim Lumpkin, who's still in the faculty at Vanderbilt. He hired me to help coordinate communications between community action groups and the Vanderbilt Engineering School. They could provide technical expertise to community groups to combat some of the legislature proposals that may have an adverse effect or impact on their homes and then neighborhoods. And I was being pretty effective in that job, so much that I understand that Mayor Briley at that time contacted Vanderbilt and told them that the program didn't back away from this trouble they were causing, which I was causing, I guess.
Not the first time, huh?
First time. But it didn't back off. That the city would review Vanderbilt's tax exempt status, which kind of scared everybody. And so again, the request was made by the university for Mr. Blumstein to terminate my service. And again, he raised academic freedom. And so I was not fired.
When tell us about this thing where the public television station telecasted the Metro Council public hearings on the amendments. What happened with that?
Well, one of my proposals that was adopted by the BIPs was to have the Metropolitan Council meetings and public hearings televised on public television, so that the community at large would understand basically what was happening in their community with respect to these really draconian federal programs that required enormous acquisitions of property at the expense of poor and elderly homeowners. It affected not only the lily white, if you will, communities surrounding Vanderbilt, but it also affected the minority communities in North Nashville and East Nashville and South Nashville. So that we all had an interest in what was going on, but nobody was able to follow it because it was all done in the old-fashioned way. Announcement of a public hearing, city courthouse. People go down there, and there was limited seating of maybe 100 people. You know, if 1,000 people showed up, it wouldn't make any difference because they couldn't talk. So televising this would be a boon to the idea of transparency. The idea was accepted by Channel 2 and Channel 8. Channel 2 was the ABC affiliate, I think, at the time. Anyway, the two stations were about ready to swap the frequency. And Channel 2, the ABC facility, had mobile units that they could set up in the council chambers to televise these hearings. And they did that, and it was so popular, and that both stations and the city agreed to allow these council hearings and council meetings to be televised. And so it's been since about 1976, maybe, that Metro Council meetings have been televised, and the entire county can see what their legislators are doing.
That's a good thing. Now, and then in 1973, you were admitted to UT Nashville Law School, but you didn't go because you had too many elder friends who needed you to help them fight urban renewal and the condemnation of their homes. Is that correct?
That's right.
Okay.
Yep.
And then you applied to Vanderbilt in 1974. You were admitted, went to Vanderbilt. And did somebody call you that day? congratulate you on your admission?
Yes, it's interesting. The day I received notice that I've been accepted to Vanderbilt, I got a call from Vice Chancellor George Kaludis, who was the Vice Chancellor for Business Affairs at Vanderbilt, congratulating me on my admission to Vanderbilt. And he apparently knew about my admission before I did. And I'm sure that they were excited with the idea of taking me off the street and being so buried in books in the law school, trying to study law, that I would not have any time to bother with Vanderbilt anymore.
And that didn't occur, right?
No. In fact, it probably made it worse for them.
Okay.
So begin to understand what I should be doing.
Okay, so then in the summer of 75, you were the lead plaintiff in Johnston versus Department of HUD. Can you tell us what happened in that?
Well, in 1970, the Congress adopted something called the National Environmental Policy Act, and it was signed into law by President Nixon. One of the things that occurred was they developed an Environmental Protection Agency, which promulgated rules and regulations. Well, one of the rules and regulations they promulgated was that an environmental impact statement would be required for all federal programs, all federal projects that might have an adverse effect on the quality of the human environment. And then the question was, well, does this act apply retroactively to ongoing federal programs that were already underway at the time the act was passed? This was an open legal question. I was together with two other residents of the area, Howard B. Johnston Jr. and Gary B. Crawford, who was also a law student. We signed up to be plaintiffs because of our standing as residents of the area being affected by the urban renewal project, to complain that this was an ongoing federal project that needed to have an environmental impact statement, that no impact statement had been published, and therefore the project should be enjoined until an environmental impact statement was published and accepted. And the university and the housing authority and HUD all opposed to this complaint. However, Judge Elclore Morton, the federal judge in charge of most of the federal claims that were coming through district at that time, was not impressed with the university's position. And so he issued an injunction, thinking that, how difficult could it be to do an environmental impact statement?
So when George Kaludis, the Vice Chancellor of Business Affairs, he got the copy of Morton's order, what did he say about you?
Well, we had, working in the Vice Chancellor's office, a couple of area residents that were easy transmitters of gossip and intelligence. But I heard a report that when the Chancellor received this latest injunction, he said out loud, "Every time I turn around, that goddamn son of a bitch is on our fucking payroll." So he could only be talking about me, I guess.
And what were you doing on the payroll at that time?
Well, at that time, that summer, I had a job as a graduate assistant supervising an engineering school undergraduate research project
Okay.
dealing with energy conservation.
Then in 1976, as you say, you graduated the top 3/4 of your class.
That's true. Not 3/4.
And you passed the bar and you went to work for Bo Edwards.
That's true.
Tell us about this one. Things I learned from Bo's office, they ask questions. What about the one about the bad check?
Oh, well, Bo was a criminal defense attorney. And he had a number of clients that also had civil claims that they wanted him to address, but he was tied up mostly in his criminal defense work. So he hired me to handle his civil claims and as best I could. So one of his clients came in and said he had bad check from somebody that he wanted to sue on to collect. And I said, well, what was the check for? He said, it doesn't make any difference. It's a bad check. So we sue him, we get my money. I said, no, we really need to know what the check was for. He said, it's not relevant. It's not important. I said, well, I'm not going to help you unless you tell me what the check was for. He said, all right, cocaine. So I fell out of my chair, and obviously I didn't help him at that point, because for him to confess that he had sold cocaine and had accepted a check, it indicated a number of things. One, he was a criminal, and two, not a very smart one.
Right. So, and during this time with Bo, you got experience with 1983 lawsuits against the police in federal court, and for excessive or unreasonable force. And so who were the attorneys that you were working with?
Well, I really got involved with Dan Eisenstein. Dan is later became a general sessions judge, and he's now retired. But we still talk about some of these cases. This is the first Section 1983 case that he had, and he really didn't know what to do with it. Section 1983 is a federal civil rights statute. It says it's a cause of action when a government official deprives someone of their civil rights under color of law. Well, Dan had this client that was a young woman who had been arrested after a spat with her mother. Well, and I'm not sure what the spat was about. But anyway, her mother had called the police and wanted the police to take her daughter off her property. Well, the police didn't know what to do, so they took her to jail. The night magistrate asked her if she had anybody she could call so they could take her to stay with some relatives. She called a few people, and it was 2 o'clock in the morning, and so nobody answered the phone. So the magistrate didn't know what to do. She was downtown. She was 9 months pregnant, and she was upset. She said, well, keep you safe, we'll put you in jail overnight. So they took her off to the jail. At the jail, she was 9 months pregnant. She was hysterical. It's 19 years old. Did not know what was going to happen to her. And of course, when she was taken to the jail, they expected her to be photographed and fingerprinted and to give information for the booking officer. She was so upset she couldn't even speak her name. Well, there was a ship's commander on duty that night by the name of Lieutenant Love, L-O-V-E, Love, which is ironic. Lieutenant Love decided he would straighten this young woman out, so he slapped her across the face a couple times. And of course, she stopped crying, but she was basically dazed. And so they said, well, we'll just consider her to be a tap out, which is a term they use to describe people that are so drunk with alcohol that they can't communicate. We'll just consider her a tap out, put her in the holding cell. And in the holding cell, there were, for the women, there were about 8 or 9 other women. Most of them were probably prostitutes. We never got into the details of that. Well, what had happened was after being slapped by the lieutenant, the young woman had become incontinent and soiled her pants. And so when she was taken to the holding cell, these other women saw that she was pregnant, saw that she was wet, and figured that she had broken her water, which means that her pregnancy was about to come alive. And so they called for the matron, and the matron came in, saw the situation, and had the young woman taken to the hospital for observation. And they, at the hospital, unfortunately, they saw her condition, confirmed that she was merely incontinent, her water had not broken. But they took photographs of her facial injuries from the slapping. So we had pretty strong evidence of unreasonable force in violation for civil rights as a pretrial arrestee, if you will. And there's a 14th Amendment cause of action that comes into play at that point. In any event, we filed for it. I helped Dan draft the complaint. We did discovery, and discovery involved a couple things. One was the deposition of Lieutenant Love, and this was a classic deposition situation. Lieutenant Love admitted to slapping the plaintiff, but he said he did so in self-defense. And he had a legal pad, legal paper that was purported to be a report of what actually happened during the night of the incident. And in his report, he reflects the fact that as a child, he lost one testicle because of mumps. And he was very sensitive about anything that might affect his groin area. And he claimed that the plaintiff, this young woman who's 9 months pregnant, had tried to kick him in the groin. And he had a visceral response, and he slapped her in self-defense. And that was his. Well, that sounds pretty incredible, but nevertheless, it's a swearing contest between a police official of some standing and a 19-year-old girl who's now a mother, and who the jury wants to believe. Well, he looked at the written statement by the lieutenant, and he said, well, yes, I wrote this statement the same evening the incident occurred. And said, you have the date? Date's correct. You have the time? Yes, I have the time. And you have the year? He says, yes, I have the year. Well, it turns out that the year was 2 years later. And he had obviously fabricated this phony report, which he made into an official report to save himself, but he in fact buried himself even deeper, which is one of the reasons that the case settled when it did.
Oh, it settled during the trial?
Yeah. No, just before the trial.
Oh, okay. So then, all right, then there was a jail suicide case with an establishment clause issue. Steve Doty helped you with?
Well, yeah, there are two. Let's see. Steve worked with me on two cases. One was Heflin versus Stewart County, which was a case of over Tennessee, where a young man had committed suicide, and the sheriff had decided that because the decedent was in a jail cell hanging by the neck with his feet on the ground and his eyes open, it was a crime scene and nobody could touch the decedent. Well, in fact, when the county medical examiner came over to examine the body, he ordered the body cut down, laid him out, and claimed to have heard the last heartbeat. So we sued for deliberate indifference to a serious medical need. And we won the jury trial in that case. And the appeal by the city was on the basis of the expert testimony. We had an expert on jail standards that he had given his opinion as to whether the actions of the defendants were deliberately indifferent, which was ultimately a jury question. And the defendants were asking the court to dismiss the case because that was an improper admission of evidence and admittance of evidence. And the court said that expert witnesses can give opinions on the ultimate question from the jury. So that was a fairly significant clarification of the law of evidence at that point. The other case that I had with Steve, Doe versus Porter, this was against the city of Dayton, Tennessee. If you recall, Dayton is the city that was involved in the Scopes trial years ago. Apparently, they have a college down there called Bryan College. I guess William Jennings Bryan, one of the lawyers that was involved in the Scopes trial. College has a Bible course, and they have Bible students. And they had a contract with the city of Dayton to teach Bible to elementary school students at the age, I guess, of third grade and fifth grade. And it would be a clear violation of the Establishment Clause. We had to file suit using pseudonyms for the plaintiffs because of fear of physical retaliation, because the opinions of the local community were that teaching Bible in any school was proper, and regardless of what the Constitution or the courts had to say. So anyway, we filed suit and ultimately got an injunction out of the Eastern District of Tennessee, and a permanent injunction. But the problem is that because of the fear of physical retaliation, no one was willing to step forward and ask that the injunction be enforced. So I suspect that the courses are still being taught today. So it's a paper victory.
Now you, I'm sorry, we've got in 1980, you left Bo's office and went to establish private practice of your own. Is that correct?
Yeah.
Okay. So tell us about the practice of using canine dogs to interrogate witnesses and your involvement in that.
Well, I had probably 3 or 4 cases, some with Dan Eisenstein and some by myself, where the canine unit at the Metropolitan Police Department was basically out of control. They were not being properly supervised or disciplined, and the individual officers, not all of them, but some of them, would brag about how vicious their dogs were and how many bites they had each week. A bite was their term for an arrest made with the assistance of a canine. Their view was that the dogs had to taste blood in order to keep them aggressive. So they were very, very reckless in terms of how they handled the dogs. One of the things that they would do was, once the suspect was under arrest, they would use the dog to terrify the suspect into confessing whatever crimes that he might have been engaged in, or confessing where the loot was that had been stored, if it was a burglary or whatever. And this obviously is at least in the 20th century, was considered to be unnecessary force and abuse of police power. We had 1 or 2 cases that actually went to trial, 1 or 2 cases that were settled. The cases that went to trial were lost because basically the jury, I think, did not believe that it would be appropriate to award money damages to a criminal. And so that's one of the difficulties you have with these kinds of cases. But in any event, because there were so many cases being brought, I brought, I think, 3 or 4. There were some other attorneys in town that brought a couple of cases. And what was happening was the bragging, if you will, of these canine officers about how mean and vicious the dogs were was so thoroughly documented by the police department themselves. They would go to the hospital where these people were being treated for dog bites, and they would take pictures of the dog bites, and then they would post them on a bulletin board bragging about what their dog had done the previous week. All of these pictures were discoverable, obviously, and showed that there was a pattern in practice of this kind of misbehavior on the part of the police. And I think the Metropolitan Legal Department finally dropped a hammer on the police department and said, you can't do this anymore, because one of these cases is going to be won, and when it does, it's going to be damages big time. And so for at least 10 or 12 years after that, there were no serious dogfight incidents that were reported to me.
What about the case of Allen Key versus City of New Johnsonville? Have
Well,
interesting facts.
That we call that the penis case.
Right.
This was a case involving a police officer in the city of New Johnsonville, and he had the bright idea that he would train his own police dog to be one dog for every purpose. No narcotics. He could attract fugitives. He could apprehend fugitives, and there's a couple other special tactics that dogs are generally specialized in doing. He was going to have his dog do all three. Well, he was fairly brutal dog trainer. And I wouldn't call him a dog trainer. He just didn't know what he was doing. But anyway, he had taken his dog out with other police officers, and he would terrify his co-workers by ordering his dog to attack them and then calling the dog off. So nobody would work with him. And he was really unstable, be a kind word. But anyway, this officer was on patrol one night on the highway, and they had a report of a stolen car. And so he saw the car on the highway and took up the chase, went into Obion County, I think, Camden, MC, and the car pulled over into a residential area. There were two individuals in the automobile, and the officer could see that they were African American. So the two suspects took off in separate directions. Well, the defendant, got it out of his car and turned his dog loose, go in one direction while he went in the other direction. He was going to let the dog apprehend one suspect while he tried to apprehend the other. The dog, unleashed by himself, ran through the neighborhood. Unfortunately, plaintiff Allen Key had just, it was 10 o'clock at night. He had just finished watching the news, and he'd come downstairs from his garage apartment into the driveway of this residential neighborhood and was smoking a cigarette. And he was in his night clothes. I think he was in his underwear. In any event, all of a sudden, out of the darkness, this huge, I say huge, very large German Shepherd attacked him, and attacked him in the groin, and clamped down on his penis. Poor Alan was screaming in pain, rolling on the ground. The dog would not let go. The police officer, the defendant, heard the screams, came running up, found him, and instead of trying to help Mr. Key, he shined a flashlight in Mr. Key's face, realizing he was Hispanic rather than black. He said, "You're not the person I need." And so instead of getting his dog to release as he should have, he merely pulled the dog off of Mr. Key's groin, causing substantial injury to his penis. So that's why we call it the penis case.
And then that resulted in a settlement, a good settlement?
Yes, we had a lot of expert testimony. We also found that the defendant had tried to get his dog trained by the I guess it's the Law Enforcement Training Academy, and some courses. And he was kicked out of that course because instead of properly encouraging his dog to obey commands, when the dog failed to obey a command, he would kick the dog in the belly. And that upset all of the trainers so badly they kicked him and his dog out of the program. So we had all sorts of evidence that sufficient to defeat summary judgment. And once summary judgment was defeated, they realized they had to go to trial with a defendant that was unstable, plus a dog that was very badly trained, and a history that was pretty horrific. They settled like $180,000.
Was there another lawyer helping you with that?
Yes. Louis Cobb in Jackson.
Okay. Now, what about, here's some more important cases of yours. Myant versus Allstate Insurance Company, and Myant is the guy who used to own international market, right?
Right. Win Mint. That was a case involving the piece of property over on Trutland Street in East Nashville that was rental property that Mr. Mint had purchased. It had caught fire, and it looked suspiciously like arson. The insurance company declined the claim, alleging that Mr. Mint had somehow set fire to this property himself. Well, fire was started at 3 o'clock in the morning in East Nashville, and Mr. Mint lived in the Belmont area, which was quite a distance away. And he was home at the time of the fire because neighbors had called him, telling him that the building was on fire. So there was no connection between Mr. Mint and this fire. Mr. Mint had some disagreements with the tenants that had to be moved because he had some plumbing repairs that had to be made. In any event, the insurance company denied the claim, and we had a trial. We won the trial. One of the claims that we made was that the insurance company was liable for unfair or deceptive business practices in violation of the Tennessee Consumer Protection Act. Before that time, the exclusive remedy for claims against insurance companies was limited to the bad faith statute. And you'd have to, it limited not only the types of claims you can make at the insurance company, but also limited the amount of damages you could claim. Whereas with the Consumer Protection Act, if you were able to show willful, unfair, or deceptive business practices, you could get treble damages plus attorney's fees. So this was one of the issues that we raised on appeal. The claim had been initially denied by the chancellor, thinking that the exclusive remedy was the bad faith statute, which we had not raised. In any event, it went all the way to the state Supreme Court, and actually the case had been appealed by the insurance company to the highest court, and we cross appealed, alleging the Consumer Protection Act claim. We were able to persuade the State Attorney General's office through the Consumer Affairs Division to intervene on this issue, because insurance companies were having a field day with their unfair or deceptive business practices and other areas of the practice of some concern to the state. So there was a very powerful amicus brief that was filed by the Tennessee Attorney General's office. And the result was a declaration by the Supreme Court that insurance companies were subject to liability under the unfair or protected business practices aspect of the Consumer Tax Act. This statute was broad enough to include everything, including insurance, but it also found that we had failed to allege enough facts to establish a claim in our particular case. The conduct that we had alleged in the complaint and cross complaint was not enough to sustain improvement. But the importance of the case, and by the way, we won on the appeal on all the other issues. But the importance of the case is that for about the next 15 years, consumers were able to sue insurance companies for unfair or deceptive business practices and collect attorney's fees and sometimes trouble damages.
And what happened after 15 years?
Well, the legislature got involved and decided that it was inappropriate for insurance companies to be subject to this sort of anti-business atmosphere we had in Tennessee. And so they rewrote the statute, amended the statute so as to exclude coverage on insurance companies. So it was a temporary victory. As a matter of public policy, it was the kind of case I enjoy bringing.
Oh, okay. And what about, there was a effort of the Metro government to remove property tax exemption from a Mint Buddhist Center.
Oh, this is the case, the Kapsambot Mint Buddhist Center versus Metropolitan Government. This was a case in which the two individuals, Win Mint and his brother-in-law, formed a joint venture to purchase property that was already church property that was tax exempt and use it for a Buddhist temple and would convert it or reconvey the property to the formal Buddhist temple organization as soon as it was organized. They wanted to buy the property because it was immediately available and they felt like they didn't have a choice but to go ahead and buy it. So they did. The city took the position that because the chain of title showed that the new owners, the Kapsambot Mint Buddhist Center, was not a religious institution within the meaning of the property tax exemption statute, that the property tax exemption had been lost and the property was taxable. So the Buddhist temple, I've served as general counsel to the Buddhist temple. We filed a lawsuit challenging this decision, and the joint venture did reconvey the title of the property to the Buddhist Temple Inc., which is still in existence today. But the chain of title had been broken, and so the city pushed forward. Well, but the problem here for the community in Nashville was that if the city were to win on this issue, then more than half of the churches in Nashville would not qualify under their definition of a religious institution because most of them are religious associations. And if that were the case, then all of these churches would lose their tax exempt status. So we were able to persuade an organization called the Nashville Association of Rabbis, Priests, and Ministers to intervene as a friend of the court to explain this problem. And as a result, the Court of Appeals ruled that it was not the ownership of the property that determined whether it was tax exempt, but it was the use to which the property was being put that determined whether it was tax exempt. And since it was being put to a religious use, that it was sufficient to preserve its tax exempt status. So to that extent, Buddhist Temple saved not only itself, but half the churches in Nashville. Most of them don't realize that, but that happened.
Let's see, Matthews versus Pickett County. That's a very important case.
Matthews versus Pickett County. That was an interesting case. Mary Matthews was in the middle of a divorce action, and her husband was an alcoholic. He also owned a bar, believe it or not, in the local area up there. And he was a very violent person. She was afraid of him, and while the divorce was pending, she got an order of protection to have the police protect her from him coming around. Well, on the night in question, they actually was the night before our final hearing on her divorce. Her husband showed up at Mary Matthews' house and began throwing cherry bombs under her propane gas tanks, which, if you can well imagine, if the gas had any kind of a leak, could have ignited, if not exploding, surely caught the house on fire. So she immediately called the police. The police came out and saw her husband and basically said, he's drunk. Well, Billy Bob, they said, y'all go on home now, sleep it off, you leave Mary alone. We got this here order of protection, and you just go on home. So Billy Bob got in his truck and we drove on down the road. Well, Mary Matthews came out and spoke to the officers and said, well, he's going to come back. And they said, no, he said he was going home. You don't know my husband. He's going to come back. Well, so here's what we can do. We can take you across the county line and you can have a motel room over there and you'll be safe overnight. Okay. Well, they got her in the car and they left one officer on the scene to watch the property. After they took Mary across the county line, got her set up, came back to pick up the remaining officer. He said, you know, Billy Bob did come back and he went in the house with a 5-gallon can and then came back out and he didn't have the can. And the officer said, well, okay. So they drove up to the front porch and shined a light on the front porch and saw the doors closed. Said, well, he's gone. Let's go home. And of course, the house exploded and Mary Matthews lost everything. She had 2 dogs inside that were killed. And it was a pretty tragic event. So I filed suit in federal court under the Government Tort Liability Act and under Section 1983, because this order of protection, we argue, gave the police a duty to intervene and protect not only Mary, but her property. Judge Morton heard the case. He initially dismissed the Section 1983 case, but because Mary Matthews had moved out of state, she moved to Alabama in order to be as far away from her ex-husband as possible. He accepted diversity jurisdiction on the state claim. And so we had a trial in Cookville, and Judge Morton dismissed the case on grounds that there was no special relationship between Mary Matthews and the police at the time that required them to do anything other than do what they did, and that they were not liable. He was aware of the order of protection, but there were no state reported cases in which an order of protection created the special relationship exception to the public duty doctrine. And this was Judge Morton's last trial that he was holding before he retired. He was not going to try to establish state law as a federal judge. So we went to case was dismissed, we appealed it to the Sixth Circuit and applied for a rule. Is it Rule 23? I'm not sure. I've forgotten the rule now. Anyway, the federal courts can transfer a case to the state Supreme Court for declaration of what the state law is to be applied in a case. And so the Sixth Circuit, at our request, transferred the case to the Tennessee Supreme Court. And the Supreme Court heard argument, and we were able to persuade the court without much difficulty, actually, that an order of protection did in fact create the special relationship one-on-one with the police that required the police to act more than they did, and so that there could be liability for the police officers for what they did that night. This case went back to the Sixth Circuit, and it went back to the district court. We had a trial, and on the second trial, it was appealed again. The appellate court dismissed part of the case, and we settled the rest of it.
And you said we with another lawyer also?
Well, I had a friend, Max Mendelson. Max was a graduate of the Nashville School of Law. He had never practiced. And I said, Max, come with me to the Sixth Circuit and you can watch the fireworks. And he agreed to do that. Well, most lawyers, when they get into practice, they start at the lowest court, at the General Sessions Court. Then they go to the Circuit Court. Then they go to Chancery Court. Then they go to the Court of Appeals. And if they're lucky or unlucky, they go to the Tennessee Supreme Court. And if it's federal, they go to the Federal District Court, and ultimately to the Court of Appeals and to the U.S. Supreme Court. Max, unlike most of his colleagues, started at the top. He was introduced at the Sixth Circuit Court of Appeals, and then he sat in with me at the trial, and he inverted the usual practice of where you start your law practice.
All right, another one case of yours, Parkin v. Metro.
Perkins.
Perkins, I'm sorry.
Perkins v. Metro. Yeah, that was a case involving retaliation for filing a racial discrimination in employment claim against Metro. While the claim was filed, while the plaintiff was still employed. And so they found some way to fire her. It was pretty obviously retaliation for what the complaint was. And as a result, the case went all the way to the state Supreme Court. And the Supreme Court recognized that Title VII cases for retaliation could be brought in state court in the court of jurisdiction.
That was the first time I recognized that.
I think so. Okay, so.
Now, when I'm talking to you about your life, you said that there are many people who helped and are influenced you in your career, and we don't have time to, but I'm just going to read out these names. Is that all right?
Sure.
Okay, it was Harold Steele, Grayfield Gray, Malcolm McCune, John Carlson, Dan Eisenstein, you've already talked about him, Randy Kennard, David Randolph Smith, Steve Doty, we've already talked about him, Bob Belton, Jerry Gonzalez, John Jablonski, Eddie Schmidt, Rose Palermo, and Denny Cheatham. That you probably have more. And you said that these people enable you to take cases, interesting cases that involve public policy.
Yes, most of these cases, the lawyers already had the case, but they did not have the time nor the experience to pursue them. And I developed quite a bit of experience, particularly in the pretrial preparation aspect of these cases. So they participate as second chair, and I'd be first chair during the pretrial up through summary judgment. And if we prevailed on summary judgment, the case usually settled. But all of those came in, with the exception of Harold Steele, the lawyers. I think Wynn Nitt was on there too, maybe. He's not a lawyer. Carol Steele was an octogenarian neighbor of mine who was an advocate for separation of church and state. And he was someone who was not afraid to put his money where his mouth was. He was very active in the local chapter of Americans United for Separation of Church and State. So when Lipscomb University applied to the Industrial Development Board for a bond issue, I think $15 million for its campus expansion, Mr. Steele came to me and said, this is obviously by virtue of its tax exemption, a state subsidy, indirect subsidy to a religious institution. And I want to challenge it. So we did. We challenged it at the administrative level and then at the federal court level, beginning in 1991. And the case went up and down the appellate route for about 12 years. And we won at every stage. We won on taxpayer standing. We won on the issue of whether or not Lipscomb University was a pervasively sectarian institution whose primary purpose was subsumed in its religious mission, which was a definition that the Supreme Court had held for like 40 or 50 years. And we felt and all the courts felt was the controlling law. Well, in 2002, the case went up on appeal again after Judge Trauger at the district court level had written this beautiful 64-page opinion concluding that no way that David Lipscomb could deny that it was not a pervasively sectarian institution, therefore ineligible for this kind of assistance. Well, within a week of the argument before the Sixth Circuit on the final appeal, the U.S. Justice Department intervened on behalf of Lipscomb, claiming to the court that if Judge Trauger's opinion were affirmed, it would jeopardize President George Bush's faith-based initiatives program, which was basically federal assistance to all kinds of churches and religious organizations to perform social services in violation of the Constitution. So the Court of Appeals in a 2-1 decision reversed all of the cases that we had relied upon, and saying that the pervasively sectarian institution definition was no longer the proper test to be used in these cases, and therefore we lost. And the Supreme Court would not take the appeal. So that was a legal odyssey of epic proportions. It lasted almost 12 years. Very interesting experience. Got a lot of experience writing briefs and researching constitutional issues and reading constitutional law. And it's very disappointing, but basically reflects a tradition that is now current, that precedent that had been relied upon for many, many years, no longer controlling and subject to sometimes the wind and caprice of judges in charge at the time.
I just ask you, is there an expression in the civil rights lawyer community about you being $1 Joe that you told me about?
Oh yeah. Bobby Ray Smith versus let's see, I guess it was Tennessee Department of Corrections. I can't remember the name of the warden. This was the case where Bobby Ray Smith had been convicted of murder, and he was serving a long sentence. While in jail, while in prison, he was attacked by another inmate and stabbed 11 times. Ostensibly, the other inmate was trying to rob Ray Bobby Ray of his watch and some other items. The attack was witnessed by a jail guard. But instead of calling the code and asking for assistance for Bobby Ray, the jail guard fled, prison correctional officer fled and locked the unit door and left Mr. Ray to fend for himself. Bobby Ray Smith. Well, Bobby Ray survived, and we filed a lawsuit and under the 8th Amendment, usual punishment, limited reference to the health and safety of inmates, et cetera, back in 1983. We had a jury trial, and the jury found that the officer had in fact violated Bobby Ray Smith's civil rights by leaving him basically to die. And but they awarded $1 in damages.
Wait, did Bobby Ray survive? Oh, he survived.
Survived. They awarded $1 in damages, ostensibly because they didn't believe anybody in prison for murder should be awarded money damages for anything. So I got a judgment for $1 on a successful civil rights case, and the nickname for a while was $1 Johnston.
Did you get attorney's fees?
No.
No. The judge, oh, because
You have to have a substantial. $1 did not qualify.
and also, I mean, you just give me tons of cases, but we're getting toward the end. Tell me, did your wife contribute to your success as a lawyer?
By putting up with me, yes. Instead of taking cases that were involved lucrative fees, I tended to gravitate toward cases involving public policy and issues that I thought needed to be addressed by the courts during a time when courts were in a position to address public policy, which they are not so much now, which is one of the complaints I have right now.
Okay, all right. What advice for persons considering a law career would you give to somebody, young person?
Well, that's interesting. I'm really not sure. My motivation for becoming a lawyer was really to be able to fight to defend people's rights that were being abused by the government. In this instance, Vanderbilt University. And so my adrenaline glands overtook my judgment many times. And so I got involved in cases that were tough cases. And, win on the law and lose on the facts, or because of a jury bias or a judicial bias or whatever. And if you want to practice law as a career, you really need to think about being able to support yourself financially. And I think in retrospect, I don't think I would change anything, but if I were recommending somebody to practice law, I'd say do it for money and not for principle.
No, Joe, surely not. Really?
Well,
I mean, you said, you already told me you wouldn't change anything you did.
right.
Okay, but you're just thinking other people may not be as
Right.
devoted as you.
Or it's crazy.
Okay, now, you told me about your wife, and what's her name?
Maida,
Maida. And when did you get married? Pretty late.
1980.
And you had said that she didn't kick you out and she gave you a home and all that. Wait, I know your house. Some people know about this. We have 18 minutes. So tell us what happened to the house they tried to condemn, what they first offered, what Vanderbilt first offered for your grandfather's house, and then what happened, and then how much
Okay.
Vanderbilt ended up.
Right. Well, in 1970, my parents came to town to listen to a presentation by the Housing Authority as to what the urban renewal program was about and what properties were being subjected to condemnation proceedings if they were not sold to Vanderbilt. And they realized that my grandfather's house, which they had just inherited, was obviously a target for condemnation. So they asked the housing authority official how much they would give for the house. And he said, best we can do is $15,000. Okay, well, that my parents were ready to. They did not live in Nashville at the time. They lived in
Are they still in Bristol?
I think they lived, no. They lived in Huntsville, Alabama. Then as an engineer for Boeing. And but anyway, they did not want to fool with this hassle. But I insisted that I needed to test this if I could get more money at least. So the idea that their son could get more money for them was attractive. So they said, okay, we won't sell.
And then you got involved in all of the other stuff about the condemnation,
Right.
challenging it.
Well, so what happened was we litigated the urban renewal project on and off for like 14 years, from 1970 until 1984. Sometimes I was a law student, sometimes I was a lawyer, sometimes I was just a property owner in many different capacities. But the litigation was reaching a final stage in state court before Judge Swigert in the Sixth Circuit court here in Nashville. And Judge Swigert had a reputation of being fairly irascible and unpredictable. Nobody really knew what he would do, but we thought we would give it a shot. But my parents, my dad was just getting ready to retire. And they lived in Oak Ridge, Tennessee at that time. And they wanted to retire and move to Nashville, and they needed the money. And so I said, okay, we'll settle it. So with the assistance of Malcolm McCune, who was the attorney of record in that case, we negotiated with the university, and the price was $130,000 plus a 3-year leasehold interest in the property where I could continue to live there and have my office there.
Did you have to pay rent to them during? No, okay.
And then at the end of 3 years, I would have an option to move the house within 1 year. So at the end of 3 years, I was in the hospital being treated for colon cancer. And but some friends of mine, including my wife, wanted very much to see if the house could be moved, as it was stated in the deed. We had that right to do that. Attorney Don O'Donnelly, who was an old friend, had just come back to town. He was practicing as a lawyer at that time. He had some connections, and he found a lot that was 3 miles away from where the house was, at the corner of Cedar Lane and Belmont Boulevard. There was an 80-foot right-of-way that went from Vanderbilt Place to 31st Avenue to Lakemore Avenue to Magnolia Avenue to 18th Avenue to Portland Avenue to Belmont Boulevard, excuse me, 3 miles. And so we took a chance and contracted to move the house. We have it rebuilt basically where it is now at 2815 Belmont Boulevard. And
it's a beautiful big brick, 4 stories,
2.5.
2.5 story house right on Belmont. And how much did it cost to move it?
Well, I think it was about $25,000 to move it, but to prep it for moving and reconstruct it was probably close to $150,000.
Oh, okay, so, all right, so that's where you've lived ever since, right? And you practice out of your home, right?
Pretty much, for my car.
Where your car, right? Now we have 10 more minutes, but what is your opinion about the current state of law.
Well, I think the current state of law is in flux, and it's very disappointing in many ways. The most recent case that I have that deals with the disappointments of what I thought was established law is the city of Russell Leonard versus City of Deckard, which involved a case where the city, in order to enforce a zoning ordinance, threatened to terminate the water service of the property rather than to take the property owner to court and get a declaration. And so they did. They terminated the water service. Well, unfortunately for the city, this practice had been reviewed by the United States Supreme Court in the case of Memphis Light, Gas, and Water versus Kraft in 1978, and they ruled that a utility service created an interest, an expectation of continued utility service, created a property interest that was protected by the due process clause of the 14th Amendment. And that was black letter law, United States Supreme Court. And that court case had been cited and used as authority by the Sixth Circuit Court of Appeals in Cincinnati on 2 occasions. And one of the courts in the district of I think it was maybe the Western District also. So you had all kinds of court cases stating that this is a protected property interest. You can't deny this property interest without notice and a hearing, which was not given in this particular case involving Mr. Leonard and in the city of Deckard. Well, we sued under the Civil Rights Statute, Section 1983, in the state court. And I did not file the original lawsuit. I will run into it later when it was in the discovery stage. But anyway, the city attorney raised a qualified immunity defense for the individual defendants. Qualified immunity has been a judicially created doctrine. It's been in play for many, many years, and its definition has expanded and contracted depending on what jurisdiction you're in. But generally, the qualified immunity defense protects officers from liability unless you can show that the law involved was so clearly established that any reasonable person would know at the time that they were acting under the law, that they were violating the law or violating the Constitution. Well, clearly established. What does clearly established mean? Well, case law generally says a case by the United States Supreme Court, case by the Court of Appeals, case by a district court, a case by a state Supreme Court, or any reported case in the state court. In this case, we had Memphis Light, Gas, and Water, which was a state case, Memphis. The U.S. Supreme Court cited state law in that opinion. So you had U.S. Supreme Court citing state law for that opinion. Sixth Circuit cases, district court cases. So, in my view, as a lawyer trying to practice constitutional law, clearly established was a fact. And because it was clearly established, qualified immunity defense would not be appropriate. Well, we had several motions on this before the local trial judge, and he concluded that the clearly established law meant that the defendants had to have actual knowledge of the law at the time they engaged in whatever the incident was. And if they didn't have actual knowledge, then they were entitled to qualified immunity. which was a bizarre interpretation of qualified immunity and the established law.
Because it had been if a reasonable person would know about it.
Exactly. So I took an interlocutory appeal to the Court of Appeals, and it was denied. I took an interlocutory appeal to the State Supreme Court, and it was denied. No opinion, denied. So it was remanded back, and we settled the case for loss of rent and 1/2 my thing. If I pursued it further, there was a big chance that I could establish some very bad law.
Right, right.
So no matter, when you're challenging public policy, be careful what you're asking for. Because you can get really, really hard.
Right. Now, is there anything, okay, let's see, we've got 5 more minutes. Is there anything that you want to say that I haven't asked you or you haven't discussed?
Well, let's see. I'd like to say some things about Robert Belton.
Yeah, that's a good question.
Robert Belton was a professor at Vanderbilt University. He had just come on the faculty, I think in 1975 when I was a junior. And I never had any courses with him, but he was teaching basically employment law, Title 10, employment discrimination law. And I first encountered Bob when he had been joined by Malcolm McCune and his law firm in a class action case against the state of Tennessee Department of General Services for race discrimination. The plaintiff's name was Wallace Duncan. He was an automobile mechanic in the Department of General Services. Anyway, Bob and I, by the way, that case, Wallace Duncan won on the individual claim, and the class action was dismissed after about 5 years. Anyway, Bob and I worked together on Title 7 cases on and off for the entire time he was on the faculty. He had an arrangement because of his prior professional experience before becoming a professor there. He was lead counsel for the NAACP Legal Defense Fund. He had argued before the United States Supreme Court the landmark case of Griggs versus Duke Power, which established the principle of disparate impact as a grounds for claiming employment discrimination, which was revolutionary at the time. Anyway, Bob and I worked together on a number of cases. He would basically steer me in the direction I needed to go. I would do the legwork, the footwork, act pretty much like a solicitor would in the British system, as opposed to a barrister that does the actual court work. But all the cases we had were successfully settled after summary judgment was denied.
Summary judgment on behalf of the defendant.
On behalf of the defendant. So, but it was a wonderful experience. Bob Belton is no longer with us. He passed away. And it's a real loss, although I'm sure that given the most recent cases decided by our current Supreme Court, including Clarence Thomas, Bob is probably rolling over in his grave.
Well, Joe, thank you so much for doing this. It's been a great deal of fun to talk about your history, and I'm so glad you did this for the Bar Association.
Well, thank you for the invitation. I'm really embarrassed in a way because I never really look over my shoulder to see who's watching. I just keep my head down and keep trucking.
Okay, thank you.